All right, let's open our casebooks to what is, let's be honest, a notoriously tricky area of Indian law, going after public officials for corruption. We're going to break down the key sections of the Prevention of Corruption Act that every single law student absolutely needs to get their head around.
So let's say you suspect a public official is corrupt. What do you do? How do you actually get them into a courtroom? Well, it's not nearly as simple as just filing a normal complaint. You see, the law has kind of built a fortress around these positions, and your first job is to figure out how to get past the main gate.
And that first gate is a big one. It's known as the sanction shield. Now, for any of you studying corruption law, Section 19 of the Act is your cornerstone. It sets up this huge barrier that every single case has to clear before it can even get started. It's called the previous sanction requirement.
So what on earth is a previous sanction? Well, in legal speak, it means a court cannot take cognizance of a case. In plain English, the judge can't even formally acknowledge the case exists. They can't look at the file, they can't hear evidence, nothing, until the government or the official's boss gives the green light to prosecute. It is an absolute mandatory first step.
Okay, so who gets to give this all-important permission? The law is really specific. If we're talking about central government employees, it's the central government. For state employees, you guessed it, the state government. And for everyone else, there's a simple rule of thumb. The authority that has the power to fire the official is the same one that has the power to approve their prosecution.
Now that's how it works for, an official police investigation. But what if you're a private citizen? What if you see something and want to initiate a case yourself? Well, the law says you can, but it lays out a very specific and pretty rigorous path that you have to walk.
This whole procedure, it basically acts as a filter. As a citizen, you can't just fire off a letter asking for sanction. No. First, you have to file your complaint in court. The court then becomes the first gatekeeper, and only if the judge finds some merit in your complaint do they then point you towards seeking that sanction. And even then, before a final decision is made, the public servant gets a chance to be heard. The whole point is to weed out malicious or frivolous complaints right from the start.
Now you might be wondering, couldn't these requests just get lost in a bureaucratic black hole forever? Well, the law tries to prevent that by putting a clock on it. The government or the competent authority has to endeavor, that's the key word, to make a decision on a sanction request within 3 months of getting it.
So, while the system has these checks, it also has a clock. They can take an extra month if there's some really tricky legal questions to figure out, but it can't just drag on forever. And here's the critical part. Any reason for taking that extra month has to be justified and put down in writing.
Okay, so let's imagine a case gets that golden ticket. It gets the sanction, and it finally moves to trial. At this point, the entire dynamic in the courtroom just flips on its head. And this is all because of a really powerful and pretty unusual legal tool that we find in Section 20 of the Act.
Just focus on that key phrase. It shall be presumed unless the contrary is proved. Whoa. For any of you who have sat through a criminal law class, those words should set off alarm bells. They signal a radical break from the absolute bedrock of criminal justice, the idea that you are innocent until proven guilty.
And here's how that shift actually works. In a normal criminal trial, the burden is always on the prosecution to prove guilt. But under Section 20, as soon as the prosecution proves that the official took some kind of undue advantage, the law just presumes it was a bribe. The burden of proof literally flips. It is now up to the accused official to prove that the money or favor they received was totally legit. So, because of this massive shift in the burden of proof, what the accused person says themselves becomes unbelievably important. The law gets this, and so it has very specific rules under Section 21 for when that public servant can actually take the stand.
The law calls the accused a competent witness. This basically gives them the right to get up there, take an oath, and tell their side of the story to try and disprove the charges. But this right isn't just a free-for-all. It comes with some really crucial protections to make sure the process is fair.
And these protections are key. First, the decision to testify is theirs and theirs alone. The prosecution can't drag them onto the stand. Second, if they decide to stay silent, that silence cannot be used against them to imply they're guilty. And finally, the trial has to stay on topic. The prosecution can't just start digging up unrelated past mistakes or attacking their character unless some very specific legal exceptions are met.
So, we've looked at the sanction shield, this wild reverse burden of proof, and the rights of the accused as a witness. Let's zoom out for a second. What's the big idea here? Why does this incredibly complex system even exist in the first place?
The whole thing, from start to finish, is a carefully constructed balancing act. The law is trying to build a system that can actually go after corruption effectively, but without completely paralyzing the government. It's designed to strike this really delicate balance between several competing and, very important, public interests.
Think about it this way. On one hand, you absolutely need a strong law to hold powerful people accountable. But on the other hand, you have to protect honest officials from being buried under a mountain of baseless lawsuits. Because if that happens, the whole machinery of government could just grind to a halt. The entire system we've just talked about is trying to do all three of these things at once.
And that brings us right to the central debate that surrounds this law, one that lawyers, judges, and regular citizens are grappling with every single day. Is this intricate fortress of procedure a necessary shield for good governance, protecting the honest folks, or has it become a bureaucratic maze that ends up delaying justice and protecting the corrupt? That is the critical question at the very heart of India's fight against corruption.